Good morning, Mr. Thobane.
Good morning, Chief Justice. Good morning, Honorable Commissioners.
So you studied at Turfloop, as it then was.
Indeed, I did, Chief Justice.
Yes, that's where you got your B.Proc degree.
Correct.
And what have you been doing over the years?
Over the years, I've practiced primarily at Mpumalanga, Kwamsanga. I've had a modest practice there, and I have from time to time done work in major cities, but I've been based there throughout.
Did you, like many of us, start with criminal work and maybe divorce, or what was there something else that you were doing primarily?
It is true, Chief Justice. That's how you start out in the the type of practice that you do your articles. If it's a criminal practice and MPA practice, follow that line, and as soon as you get admitted and you venture on your own, you also assume a life of sorts. So it was like that with me as well.
Yes. And you've been in practice for some 20 years now, am I right?
That is correct. In July, it was 20 years.
Yes. And you've acted as a judge, and you've obviously enjoyed it, otherwise you wouldn't have come here, am I right?
It's so, it's true.
Yes. What are the challenges that you encountered as an acting judge? Very briefly. What is it that you would suggest should be done differently to improve the environment that we have been told is already welcoming? What more could possibly be done?
I think as a prerequisite, every acting judge who gets an opportunity to be called up must undergo introductory training, because the environment is different, and if you had not been exposed to training, you may struggle. But by and large, my experience has been a good one, and I think the environment is helpful to someone who comes in without any experience.
We do offer training under the auspices of the South African Judicial Education Institute, but attorneys hardly ever make themselves available. Do you know of any reason why? They used to attend while they were being paid something, and now that we're not able to pay them anything at all, they don't make themselves available. Is there anything that could be done to help them take advantage of that opportunity?
Chief Justice, I believe most practitioners are keen to attend. I was under the impression that there is limited space for the uptake, but I mean, I stand corrected.
Yeah, no, there's no limit. Very well, JP.
Thank you very much, Chief Justice. Good morning, Mr. Thobane.
Good morning, Judge President.
Mr. Thobane, my role as the JP of the division is to allow you an opportunity to tell the Commission what you have done in your acting stints, what work areas you were involved in, what judgments you wrote, and any other issues related to your acting stint. So that's my role. In a nutshell, it's for you, through my leading, to tell the Commission that when you say you're ready to be appointed, this is why. The first part I start with is the spreadsheet in front of you. In your application, you said you spent about 69 weeks. Is that correct?
Isn't it so, Judge?
Right. And it's because this past term, you've acted for the whole term. Am I correct?
It's true, yes.
Thank you.
Excuse me.
You, when the CJ led you, you explained that when you serve articles, you follow the patterns or the work areas that the firm offers. You've done 16 weeks. I think it should be more with the 9 weeks that you've added of unopposed applications. What was your experience when you first acted in that court?
Well, Judge President, I think the first thing that strikes you is the complexion, for lack of a better word, of counsel who get to handle matters in that court. Africans are in limited numbers, and whenever they hand up a matter or their matter gets called up, you find that it's matters, your normal procedural matters, whether it's an application to compel, whether it's an order about this and that, but it's not something of substance. So that was the first impression that I got. And I'm afraid, having been on acting stints since 2013, that picture does not seem to improve. That's the first impression that I have, JP.
But I'm just talking about yourself in terms of being able to deal with the work. You've done most of your acting stints in Pretoria as opposed to Johannesburg.
Right.
The volumes, the complexity of the work, is there anything you can say to the Commission about that?
Well, at first it was a challenge. But when you are willing to exert yourself and are willing to ask for guidance as a start, because the environment is a different one when you come in for the first time. But over time, I've gained experience. I believe I have handled matters on most areas of the law, and I've delivered judgments where matters needed to be dealt with. So I think my exposure was rather broad. Yes.
Maybe you can remind me. I don't recall me and you having had a fight about any own goal you would have scored in that court.
It is true. It is true, JP. It's not how I was raised to pick fights with elders, but I try to exert myself so as not to be on the wrong side of doing things.
My spreadsheet suggests you did a third court matter in the third term.
Yes.
Tell the Commission what the third court matter is.
There were two matters that I did in the third court. One such matter involved the Tshwane municipality, and another one related to fight between litigants about custody and liquidations.
These are matters that are opposed motions but don't get put in the normal opposed motion role.
That is true. Those are matters that are involved. Most of the time they involve senior counsel. The documents that one gets allocated are voluminous, and you must give them the attention that they deserve.
How long did it take you to hand down those judgments after hearing argument?
Well, at the end of I think one matter I handed down judgment in a matter of days. I think it was 2 days or so. The other one may have taken a bit longer, maybe a week or so, but when you leave that court, you leave it with, or I left it having delivered my judgments.
But now, your practice was varied. Correct. But you've been able to handle the work you allocated to you in Pretoria. And I've counted something like, I think, 45 or 46 judgments that you've written totally. And I think you're the second candidate who's done criminal trial work during their acting stints. And you've done the most. You've done about 14 weeks in total.
Yes.
Right. Is there anything else you want to tell about your readiness to be appointed?
I would like to believe, Judge President, that I have been exposed to all the areas of the law, and I have exerted myself and tried to account the best I could in all those areas, and I believe that I'm ready, all considered, and the judgments that I've prepared, I would like to believe that they also, in a way, go towards speaking for themselves, and I am ready to be appointed for judicial office.
Thank you, Mr. Thobane. Thank you, CJ.
Thank you, JP. MEC.
Thank you so much, Honorable Chairperson. Good morning.
Good morning, Mr.
I can see you studied during turbulent times at the University of the North, and you remained apolitical ever since. Is it a correct observation?
Well, at TEFLOP, you could not be apolitical. You had to be political. Perhaps where the difference is would be where you do not put your color to the mast. But insofar as being involved in student politics, so to speak, I was involved.
In politics outside school?
Politics outside school, I've always kept it within my professional realm. Ever since I was admitted as an attorney, I belonged to NADEL. And those who are in NADEL would say, NADEL is the political home of progressive lawyers. So whatever contribution one could make, it was within such structures in NADEL.
But you represented victims of TRC. What was the experience and the kind of assistance that you provided?
The assistance we gave was supportive in nature. We prepared witnesses, we prepared statements, much more senior, because I was junior at the time, and much more senior colleagues would then do their presentation and so forth. But our role as junior practitioners at the time were limited to consultation and taking statements.
I know you're a South African, and I've heard the experience that our Judge President alluded to in presiding in some of the cases in Gauteng. What is your experience of Gauteng compared to where you spent your time in Mpumalanga?
Well, there's no difference. There's no difference. I think Gauteng is particularly the division that I've been exposed to, which is Pretoria, largely. I've also done matters in Johannesburg, but I believe the kind of experiences that one comes across in Gauteng are similar to those that one would, meet up in other provinces. But my experience has been a positive experience.
Thanks, Honorable Chair.
Thank you, MEC. Commissioner Malema.
Morning. What's your take on racism?
Morning, Commissioner.
What's your take on racism? Or let's start like this. What is racism?
Well, racism, I believe it's a system or a thinking that seeks to advance the narrative that someone of a different race is superior and someone of another race is inferior. So that is my take on it.
What is sexism?
Equally, sexism would take a similar kind of, when one believes that a particular sex is superior to another and another is inferior to the other.
What is ageism?
Well, it's. I think the three questions are related. in a way. Ageism, I would like to explain that it's when someone of a particular age holds a view that someone of a different age would not meet certain requirements, if I could leave it at that.
Do you subscribe to any of those isms?
No, I don't.
So what do you mean you can't fight an elder?
It goes to how one is brought up, firstly, and secondly, it goes to the environment in which we work. The context of fighting an elder, it was in the context of the JP having said there was nothing that can be described as a fight in our relations.
It doesn't matter how irresponsible this elder is, because you are brought up not to fight an elder, an irresponsible JP who happens to be older than you will never fight this old person. Because he's old.
Well, it depends how one then describes a fight.
Is that not ageism?
I don't believe it is.
Here is an irresponsible leader, old as he can be, not compliant to the Constitution, not compliant to the oath of office, all those things that we look up to from or expect from an elder. But because I'm brought up not to fight an elder, I won't do that. Is that not a phenomenon of ageism?
Well, I would like to believe, taking the example further, that there would be structures, and there are structures within the judiciary that would seek to address those failings on the part of the JP that you've described. And it would not necessarily be up to me to pick up a fight. If there is a need for me to participate with the view to bring to the fore what my experience has been, I would obviously participate, but within those bounds and with the respect and decorum that I've indicated I have within me.
Those kids who were fighting in 1976 went to an extent of defying their parents. Others went to exile without the permission of their parents. Others went to disrupt the activities of elders in beer halls and kicked bottles down and turned tables around. Mandela himself disrupted meetings of elders in the form of Communist Party meetings and turned tables around. He was not properly brought up, ne? Because he fought old people.
Well, I wouldn't say so. I'm sure they've got their personalities. Everyone has got his own or her own personality. They've got their own way of doing things. And I would not necessarily label them as having not been brought up. But they chose to do things the way they chose. And I do not judge them, or I do not label them as having acted out of 10.
So any judge that is scared to confront old people because they are old even when they do wrong, that judge will be suffering from ageism, isn't it? And not fit to be a judge. Because we don't want a judge that suffers from a phenomenon of ageism.
Well, I think it would be, if you choose not to challenge someone because of age.
No, my worry is that the judiciary is constituted by a lot of old people. And you're going to have to fight with them. Amongst others is your JP. and you are brought up not to fight with old people, is that not a cowardice for a judge?
No, it is not. The fight that has brought about this exchange, this discussion, is not a fight in the true sense of a fight. It's an engagement. And as a colleague and an equal, if one is called upon to engage your senior, then obviously you would engage, but you do not refrain from engaging simply because someone is an elder. If there's reason to engage, you do engage, but I would not go as far as calling that a fight.
Thobane, you're the one that started the issue of the fight, and we know the context why you started it. I'm not talking about boxing or Mosako in Venda. I'm talking about what you and JP were talking about. Don't bring any other definition of a fight except what we're talking about here. You are the one who said you were brought up not to fight elders because of what JP said. I'm saying in that context, if the JP was to engage in a manner, in a conduct that is unacceptable and requires of you to raise that matter which can be called a fight, will you be prepared to take up that fight?
Well, again, I repeat that there are structures within the judiciary that are meant to address such issues. And if I am to play a role in participating in those structures, I would play a role within those structures in the manner prescribed in those structures. I would not necessarily call that a fight.
No, you have to fight with the JP. Remember, you are being called upon to position of leadership here. We're not talking structures. You are a judge. There's no structure called a judge. You are a judge. And the JP comes and gives you illegal instruction, which is not part of your duties, and you have to now engage in what we call a fight, but confrontational type of a situation where you say, I can't comply with an illegal things and all type of things. Because of how you are brought up, you are going to have to comply because he's an elder and not pick up a fight like that.
Well,
because his comment was about your professional conduct,
yes,
that he didn't have to come and fight with you because of your own making a misconduct. That's what he was talking about. And I'm saying to you, when you find yourself in a similar position where you have to fight with him because of a professional related matter, but you are brought up not to do that, then what happens?
well, the example that you've actually given, it assists me, because if I am to be given an unlawful instruction, then I'm duty bound to raise it with him and not to obey an unlawful instruction. So, yes.
Therefore, the story that I'm brought up not to fight with old people falls off.
Well, it remains.
How does it remain? Because we have to now fight with him about the issue which is illegal and wants you to do it. It doesn't matter how old he is. He wants you to do an illegal thing and you are bound to fight with him.
Well, what remains is the following. Firstly, I still say that I respect my elders, I respect the JP, and in answer to his question, I indicated that I was not brought up in a manner where I've got to fight my elders. We park that one. In a professional engagement with him, if circumstances were to arise which would call upon me to utilize the structures that have been put in place within the judiciary to challenge that which I do not agree with, then I would do so within that realm.
Well, your answer to bring about the issue of being brought up to respect elders and all those type of things is not what the JP was asking. It was in the context of professional conduct. You brought that issue because you wanted to patronize the JP.
Well, I do not believe so. If that is the impression that I created, then I would wish to correct that it is not what I meant.
Thank you.
Commissioner Singh.
Thank you very much, CJ. Good morning, and good morning, Mr. Thobane.
Good morning,
I think in the word is hlonipa in Zulu, hlonipa, respect. But one can also respectfully disagree.
That is true.
Thank you. Mr. Thobane, I see the Law Society of Northern Provinces has sent the JSC, the Secretary, a letter dated 27 September 2016, which relates to your audit reports, not 1, but 2 years. Your audit report which was for the financial year ending 28 February 2015, and which should have been submitted by the 31st of August 2015, was only sent in 10 months later, on the 22nd of June 2016. And there are still queries to that report. So that's the one issue about the audit report. And it seems you may not have learned from that, because even this year, your audit report, which was due on the 31st of August, has still not been received. Now, what kind of explanation, credible explanation, can you give the JSC on those two issues?
Thank you, Commissioner. The explanation that I can give is the following. Firstly, with regard to the first outstanding report, the one that has got queries on them, perhaps to explain the nature of the queries, there are two. Firstly, it relates to the calculation of interest on the on my trust account. Interest is collected monthly by the Law Society. Now, in preparing a report to the Law Society, my auditor, the computation of the interest collected did not tally with that which the Law Society had on its own record. So that is the first query that has been raised. The second query that has been raised, it relates to that audit report, which my auditor filed electronically. And having filed it electronically, he did not sign it at the bottom. So there was thereafter engagement with him on those two things to ensure that the calculation of interest on the parts of the auditor does tally with that of the Law Society, and as well as to comply with signing in manuscript the audit report. So that's in relation to the first one. In fact, on that first audit report, then there is ongoing, or there was ongoing engagement between myself, the Law Society, as well as the auditor, with the view to correct that. And the second query, the outstanding audit report, which is admittedly late. The auditor that I'm using, I've been using him for more than 10 years. And he just delayed, and he has not filed my audits timeously. I'm embarrassed, but that is just how it is. And even on that one, I've opened a direct line with requested the Law Society to engage directly with him with a view to expedite filing that audit report.
You are aware of the Public Finance Management Act and what's contained in the Act?
I am, yes.
And you do realize that not submitting your audit reports on time without credible explanation is a serious transgression of that particular Act. It borders on financial mismanagement. I'm just asking if you're aware of that.
I am aware, yes.
Now, you did say that you have a modest practice. I take it that with your modest practice, you have an accountant or a bookkeeper that completes your books and submits it to the auditor. Now, one is surprised that you have an auditor for 10 years, and this auditor suddenly is not in a position to audit your books timeously and properly. Is there not more to it than the eye meets in terms of the audit?
Not at all, not at all. It is just a mere hiccup. It has got nothing to do with whether or not my books are in order, whether or not there's something untoward taking place within my accounts. No, it has got nothing to do with it.
But one would imagine that the Law Society would be demanding, proper financial records because you're handling clients' money held in trust for them.
Well, that is true. That is why I've been open to say to them, I've got a challenge with my auditor. Would all of us please engage and ensure that I do comply with the rules? And that is what has been taking place.
So the last question is, you're leaving it now to the Law Society to help you out in dealing with your auditor, because you said you've asked the Law Society to contact your auditor and see if we can expedite the audit. Is that how it's going to be? And we'll all have to wait.
No, Honorable Commissioner, it is on my shoulders. It's my responsibility to ensure that there is compliance. The fact that there has not been compliance, and the fact that I have, once there has not been compliance, the Law Society informs you. And you must give some sort of explanation as to why there has been a delay. And the explanation that I've proffered was to the effect that the auditor has not been up to date with his filing. But the responsibility rests on my shoulders. And by involving the Law Society, I was simply answering the question that it is not like I've taken a supine role and I've sat back and not done anything. I've involved the regulator and I'm attending to it.
Finally, hypothetically, you are presiding over a matter where the Law Society or somebody, Joe Soap, takes an attorney to court for failure to submit audited reports to the Law Society on time. And the kind of explanation you're giving us at the JSC is the kind of explanation you hear from that particular attorney. How would you react?
Well, each and every matter is dealt with on its own facts. I would imagine I would have to deal with that matter based on the facts that would be placed before me at that hearing.
But we have the facts. We have the facts. The facts are, because I said it's hypothetical, that the facts are those that you've given us here today.
Perhaps then you must just repeat, because I'm not sure exactly what the question is.
Question is, you're presiding, you're sitting there as a judge, and a matter has been referred to you where an attorney has not submitted their audited reports.
Yes.
And it's a transgression of the law.
Yes.
And you have to deal with that particular matter, but in terms of the law. And the facts are the facts that you've presented to us. Hypothetically, the facts are the same as you've presented to us here as the JSC. How would you deal with that matter in that case as a judge?
But the matter that would have been before me, you're saying who has brought the attorney to court?
Let's assume that the Law Society has preferred charges against you as an attorney for unlawful conduct or for financial mismanagement as a result of these audited reports not being submitted on time. How would you react in that case?
Well, the Law Society does its investigation, and it goes to court on matters once an investigation has been completed. And ordinarily, the Law Society would have a system of dealing with particular types of complaints. And I would imagine they would not go to court on a matter such as this. They would refer it to their disciplinary department for them to deal with. If established that there's something wrong with the attorney, then they would obviously go to court. So on the postulation that you have presented, I don't believe that the matter would at that stage come to court. Hence, I mentioned that the facts would dictate.
Thank you, CJ.
Thank you, Commissioner Singh. Commissioner Nyambi.
Thank you, CJ. Morning, Mr. Thobane.
Morning, Honorable Commissioner.
What are the attributes of an effective and efficient judge?
Well, firstly, to keep an open mind, not to prejudge matters. Secondly, to be decisive and firm, to be courteous, and to apply the law without fear, favor, or prejudice. I would say those are the underlying attributes.
In your questionnaire, you reflected that you studied in the University of Limpopo, now University of the North. Your comment on that?
It was University of the North then. It's the University of Limpopo now.
No, I'm telling you what is in your questionnaire. You said you studied in University of Limpopo.
Yes.
Now it's University of the North. Your comment on that?
I'm sure it's a typo, because that's not factual.
What are the essential and consequences of a delayed judgment?
It's simply delayed justice to the parties. If you delay delivering your judgments, you are delaying delivery of justice to the parties. Parties want expeditious resolution of their issues, and you are harming their expectations in delaying your judgments.
My last question: if you attend a funeral, you see an elderly that is arriving, and a young boy or a young lady decide to give a chair to that person who's old, how can you interpret that situation for us?
Commissioner, remember I said I'm going to be strict. Suitability to be a judge. It's one thing if you say in a courtroom, how do you treat elderly people or people, then it's closer to
Teacher,
the
I was
situation.
addressing the issue of respect. Is there an issue that you address with the JP?
No, that I understand, but whether you give a chair to an elderly person or not, is that what a young person in your presence gives a chair to an elderly person, how does that impact on his suitability as a judge? You could put a question, whatever question to him, designed to test the way he treats people, and by extension the way he would treat people who appear before him. But that one is a bit far removed.
I want mine to leave it at that.
Thank you very much, Commissioner. Commissioner Schmidt?
Thank you, Chief Justice. You've indicated quite a few leadership roles in your nomination form, two of which I just would like to ascertain more information. The first one is your position as trustees of the Attorneys Fidelity Fund. From not being an attorney, I would imagine there would be some form of trust placed in you, but could you just expound more as to what your role is in that position? And then secondly, you were trustee of the Ukutulu Advisor Center until 2013. What was your role in that? It seems to be an NGO, but can you please elaborate?
Well, the Attorneys Fidelity Fund, it's a fund that is attached to the attorney's profession. It has a funds in respect of which are drawn from the interest that accrues to trust accounts, and those funds are then deposited with the Attorneys Fidelity Fund. In the event of theft of monies by an attorney, a member of the public approaches the fund with a view to be made good that which the member of the public would have suffered. Now, the Attorneys Fidelity Fund has a board, and it's made up of constituencies from other law societies. It meets once a month to consider those claims, amongst other things, but it operates by way of committees who meet to decide and make recommendations to the board. It is also involved in the training of attorneys, and it does support university. It grants law schools. It grants law schools monies for their libraries and so on and so forth. So my role initially was as a member of that board, just a trustee, and I then became the vice chairperson at some point of the board, but my commitments did not allow me to carry forward. So eventually, I tendered my resignation recently. And Ugutula Advice Center is a community-based non-governmental organization. It was established by members of the public, and its role was to support members of the public. So I was part of the board of that center. It was a small center, a community-based center. It was chaired by the Ndebele king, Inkosi Mabena, and who was the chairperson of the trust. And we would, in our role as lawyers within the trust, whenever there would be events, we would then go and offer free legal advice to members of the public. Yes.
Thank you, Commissioner. Commissioner Magazi.
Good morning, Date Thobane.
Good morning, Mayor.
In your acting capacity, I can see here that you have never had an opportunity of presiding or giving a judgment on customary law matters. But I assume that in your practice you have come across customary matters related issues. What is your take on matters which actually has to do with customary law in your view?
Well, the area where I am from, in Mpumalanga, customary law is practiced, so to speak. And in my role within Ugutula Advice Centers, one of the things that I did was to prepare a paper after the recognition of Customary Law Marriages Act came on board, and we prepared a roadshow and we went around educating people with a view to encouraging them to register their customary marriages. And it is an area of the law that is not receiving a lot of attention, and it can still grow, and it needs perhaps us legal practitioners to ensure that it gets the attention that it deserves and it develops like any other law. In my practice, after the act came into being, we always made it a point that we started by registering customary marriages in respect of our clients, so that whenever issues come about, it should not be the starting point to start by registering a customary marriage. But it's an area of the law that surely needs to be given attention to develop.
Are our women, as you have indicated that you've gone on a program of educational program, does our women really understand and take cognizance of this tool which will be able to assist them? That is the first question. The other one would be, still on the same, maybe looking at looking at African laws in totality. Language is one of the barriers that you come across as you go into courts, because languages, our indigenous languages, are really not that much used. What is your take on that?
Firstly, I do believe that it is not only a women problem to understand these customary marriages. It's a societal problem. I think just by and large, it is not given the attention that it should in the society. So that would be the starting point. And perhaps we as practitioners, we can play a better role in assisting our people understanding that a customary marriage is, just by way of example, a customary marriage is as good as any other marriage that ought to be recognized, that is recognized by our constitution.
Thank you, CJ.
Thank you very much, Commissioner. Commissioner Nsebeza.
Thank you, CJ. Mr. Thobane, I think you didn't seem to grasp what Commissioner Singh was trying to get at. And it was not for you to give him a technical reply about whether it's going to be disciplinary or an application for a strike-off and all of that. All he wanted to say, ask from you, is whether on your version of events, if they were presented to you, you would be satisfied as a judge that the story that has been put to you about your audits is reasonably satisfactory. I'm putting that question to you. Do you feel you have given the Commission a satisfactory response about, firstly, why you didn't submit your audit report timelessly, and secondly, what the status is today about your audit report?
My answer, Commissioner, is an emphatic yes. I think I've accounted satisfactory.
Have you accounted as to why you didn't submit timelessly?
Yes, I have.
And are you satisfied that the reasons that you have given are satisfactory?
I believe I am satisfied. Prior to me accepting my nomination for judicial appointment, and prior to the letter of good standing from the Law Society, it is something that would have been considered. And the Law Society also, in the letter where those issues are raised, they do indicate in that letter that they do recommend us, those who are listed there, for judicial appointment.
Which raises another question that I think I need to raise with you. I see that you are a sole proprietor in your practice which you call a modest practice.
Yes.
And in your letterheads, I see that it is only you who appears there.
Yes.
Do you have any persons who assist you in your practice who are qualified to run the practice whilst you are acting?
Yes. I have been acting on an on and off basis since 2013. And I employed services of a professional assistant who is full-time based in that practice and who runs the practice in my absence.
So when you are acting, your practice is run by a professional assistant?
That is correct.
How long has he or she been in practice?
She has been admitted I think 2013, if I'm not mistaken.
2013?
Correct.
Less than 3 years in practice?
Yes.
Does the person comply with, I'm not so sure now, with what the legal requirements are for a person who, or do you have any candidate attorneys?
Yes, I do. One.
And when you are acting, who takes care of the candidate attorneys?
Well, the candidate attorney who was assisting me, the period of clerkship is lapsed. In other words, it's finished. He's just awaiting
writing exams. So it's not really a candidate attorney per se in terms of going to court and stuff like that. It's someone who's been seconded by a colleague to my practice to gain experience, because I've both a small practice, but it's a practice that has got various areas of practice.
Are you answering the question? When you are acting, who is responsible for the candidate attorneys?
Professional assistant.
Your professional assistant, who has in practice for less than 3 years.
Yes.
Is that in compliance with the requirements of the Attorneys Act?
Well, as I've indicated, that this person has finished the period of articles. It's just awaiting writing exams.
Are you satisfied that you have given us a satisfactory response to the question?
Yes, I am.
Last question. Do you have a Ndebele name?
No, I don't.
You've never had any?
No, I've never had any.
Well, that is not your... Do you have any African name?
No, I don't.
Your names are all English, colonialist English.
You can't blame him, Commissioner.
I'm not blaming you.
He did not give birth to himself.
As the CJ pleases. Thank you, CJ.
Thank you very much. Commissioner Helens.
Thank you, CJ. Good morning, sir.
Good morning, Commissioner.
In your questionnaire, in your application, you've indicated that you have one reserved judgment, Unicorn Wonings, reserved on the 1st of August. Is it still reserved?
Well, that judgment has since been delivered, but I've picked up a few reserved judgments since then, because I then went on to, at the time when I completed the form, I had one. It has since been delivered, but I've picked up a few since then, because I was still on an acting state.
Yeah. How many do you have?
I've got 5 reserved judgments.
Looking at your list.
Sorry.
No, you carry on.
Yes. At the time when I had finished the first part of my acting stint in Pretoria, I then had to be available for a colleague who suddenly became unavailable in the South Gauteng High Court. So then I was off to South Gauteng High Court, and I did matters at South Gauteng High Court, and I was then placed on research duty where I did urgent motions. So as a result, unfortunately, I couldn't shake off the reserve judgments that I picked after that one judgment.
So in your list of cases, number 8, you've got a case of Rabatata versus the state, and you have neither a date of hearing nor a date of judgment. Is that outstanding still? Number 8.
It's on page
5 of the schedule that the JP has handed to us of your appearances with your case list.
No, that judgment has long been delivered. It was delivered 2015.
You just don't have the dates.
I just don't have the date, yes.
And then have a look at 14, 15, and 16. Page 6.
All the judgments that appear on that schedule have all been delivered.
Thank you, CJ.
Thank you. Prof.
Thank you, CJ. Good morning, Mr. Matat. Mr. Thobane.
Thobane.
Good morning, Commissioner.
You colleagues, don't do this to me. My question is a follow-up to Commissioner Magazi on customary law.
Yes, ma'am.
What is the status of customary law? The reason behind the follow-up, as a judge, there are criticism against the courts, especially on the use of customary law in the interpretation of the Constitution. So if we do give you the opportunity, how are you going to deal with the criticism on the role of the courts in respect of the manner in which they deal with matters that arise from customary law? This criticism relates to whether the courts are sensitive enough to apply customary law as a legitimate system of law, because it is argued that what the courts do, they import common law principles in addressing the issues that emanate from customary law.
Well, customary law is as good as any other type of law, and it deserves its place in our jurisprudential landscape. It has to be given attention. I think such criticism is warranted. Perhaps a restraint on the part of the judiciary is that they don't call on cases to come to them. They deal with the cases that are before them, and they deal with the facts that are before them. So you are constrained in a way when you have a matter involving customary law and issues are not broad enough for you to develop customary law. But there is a responsibility to develop our law, and that responsibility extends to customary law as well. So as someone who has seen the importance of customary law from where I practice, if given an opportunity and there are matters that come before me, I will have the responsibility to ensure that customary law is developed in line with other laws.
How, Judge? How are you going to ensure that development does take place? Because you are saying that customary law has to be given the status which it deserves, of which that status is constitutionally recognized. So how are you going to ensure that customary law is given its constitutional status? Not because it is recognized as a mere system, but it is a constitutional system that has to be given its meaning and life on how the judiciary interprets it and influences the general system of the law.
Like I indicated, as a judge, you deal with that which is before you. And for as long as there isn't broader litigation from our system on customary law, the development of customary law will not be progressive. It will stagnate. So you need, unfortunately, ours ought to be a litigious society, so that matters are brought before courts and judicial officers are able to apply their knowledge to the customary facts and the law that is before them, and to develop, to ensure that it finds its place within our constitution as well. Okay.
Commissioner Nogesi.
Thank you, Chief Justice. Good morning, Mr. Thobane.
Morning, Commissioner.
Chief Justice, I must disclose, I know you from Natal. We served together in the NEC of that organization. Mr. Thobane, on the issue of the audit, just come on a little bit on that. If you submit your audit report late, am I correct to say that the effect for such an act is that you will not be issued with your fidelity certificate for the year?
That is correct.
Is there any instance that a person would be struck off the roll just because he has not submitted an audit report?
No.
And also, if your audit report is submitted and is received by the Law Society, what would that mean in relation to the issue that has been raised?
Well, the Law Society has a system of levying a late audit fee. So whenever your report is late, they invoice your membership with a fee.
In other words, this results in an administrative fine.
It's an administrative fine, yes, a levy.
Now, with regard to the candidate attorney in your office, what does the Act require in relation to supervision of candidate attorneys?
It requires that they be supervised. It requires that they be supervised.
Now, if a candidate is not contracted to you, he has finished his term, do you have an obligation to supervise, as per the provisions of the Act, such candidate?
Not as per the Attorneys Act, but just perhaps as just an employer to oversee the functions, his functions.
Mr. Thobane, both as a member of the society and as a profession, you have been part of transformation process. What has been your contribution in our transformation? Just in a summary.
Well, Commissioner, like I've indicated, I have served in the profession for 20 years. And ever since I was admitted as an attorney in 1996, I've been a member of NADEL. I was there when the Legal Practice Act was being discussed. I was there when it came into law. I served as a chairperson of the Mpumalanga Attorneys Council for many, many years. And during my time in that position, noting the non-participation of our women colleagues, I introduced an award at the level of Mpumalanga Attorneys Council, and we called it the Woman Attorney of the Year Award. And the purpose thereof was to force colleagues to identify women practitioners and to bring them to the fold so that we are able, because the outcry was that women colleagues do not participate in these structures. And the argument on our side was that women practitioners are there, they are doing fantastic work, and we have to go out and identify them and work with them. So those are some of the achievements.
Thank you very much, Chief Justice.
Thank you, Commissioner Nyakesi. Minister?
Thank you, Chief Justice. Good morning, Dr. Thobane.
Good morning, Mr.
I get the impression that you run, as an attorney, a sole proprietorship, say for the PA that assists you in your firm. Is it a phenomenon that is prevalent, as has been in the past, among, say, the historically disadvantaged generally, or is it more of an exception?
You mean running a single practice?
Yes.
Yes, it is. Unfortunately, it's a sad reality of our society and our profession that we have many single practices, and colleagues are somewhat reluctant to come together to form partnerships. But the reality of their environment more or less dictates how they conduct practice. It's a legacy of our past, and it's a legacy that we should seek to correct going forward.
Ka Sepedi ba re tau tša hloka seboka di šita ke na re e hlotše. My apologies to those that do not understand Sesotho. I understand all the languages in South Africa, at least. Just tell me, what is it that could be done to encourage historically marginalized, short of a better description, practitioners to organize themselves differently such that they are able to create the kind of law practices that would put them in better stead to take up big work because they have the necessary capacity as a result of collaboration?
In fact, the solution lies in small firms coming together. And there were efforts in the past to do so. Because when you approach corporates and institutions as a single practitioner, issues of capacity gets brought up from time to time. And if you are able to neutralize that argument by saying that we have capacity, we've got a human resource, and we've got numbers to be able to tackle the work that we seek from you, you will be able to give it attention. The second thing, the state is the biggest client, so to speak. And if the state were to ensure that a bulk of its work go to black practitioners or single practitioners to empower them, but there ought to be structure to the whole arrangement to ensure that they are encouraged to form partnerships and they are able, because of resources, to tackle work that is much bigger than they would have been exposed to.
Are any efforts being made by the profession to strive to organize itself in that manner and to engage the state as you suggest? Or is it just an idea at this stage that still needs to be pursued?
Well, not the organized profession in the strict sense, but bodies such as the BLA and NADEL have always been at the forefront of seeking to have this imbalance addressed. But the profession itself, I'm sure that nothing has happened and nothing is going to happen if it's left to the profession to correct.
What I'm specifically referring to is obviously the client cannot organize your firm. You need to organize your own firm and bid for the work. So the part of organizing yourself in a collective manner, as we have discussed, I just want to get a sense whether there are strives by professional organizations, be it to encourage, to support, to assist practitioners to come together and to form themselves in the manner we've just discussed. Are those efforts underway?
Well, bodies like I've indicated, Honorable Minister, bodies such as BLA and NADEL, those are ones that I can think of that are in the forefront. But the organized profession itself, nothing can be expected from it. And one would understand, because the organized profession, in a way, has got many interests in it. And if you have persons sitting within the organized profession who are benefiting from the status quo, then it's unlikely that much will be achieved.
The last area I want to touch on is a follow-up on the area of the application of indigenous law in our legal system or our jurisprudence. Now, I want to separate two issues so that you understand my question more clearly. I want to separate the issue of disputes arising out of the practice of custom from the question of infusion of customary law principles of universal application in our mainstream jurisprudence. To give you an example, Ubuntu, which was applied not solely in order to resolve a customary law dispute, but was infused into the mainstream legal philosophy as a way of indigenizing it. Do you believe that that is a necessary step that and direction that our jurisprudence should be taking 20 years into democracy? And if so, how do you propose that be achieved?
Well, it is never too late to start. And just in as much as we would want to have a judiciary that is transformed and a judiciary that owes, that respects the Constitution and what the Constitution stands for, and in circumstances where you believe that that objective is not being achieved, you may introduce training. So training is one area I would like to suggest, maybe an avenue to seek to inculcate within the judiciary that sense that our customary law principles are woven into the mainstream and become part of our legal system.
And finally, is this what our Constitution promotes, or is it a good idea but not necessarily what the Constitution requires needs to happen to our jurisprudence?
The Constitution demands that it directs that it should happen, and I'm the one to say it must happen.
Thank you very much, Chief Justice.
Thank you, Minister. Any more questions, Commissioners? You've run 13 comrades and many other long races.
Yes, Chair. That's how I stay sane.
I'm suitably impressed. I know it takes tremendous strength, patience, and self-discipline to do that. Well, is there anything you'd wish to say to the Commission to round off your interview?
No, I think I have said a mouthful.
Right. Thank you. You're excused.
Thank you, Commissioners.